Welcome to Chapter 12. Americans frequently cite the Supreme Court as one of the governmental institutions they most respect, basically because the Supreme Court is seen as the arbiter of constitution and above politics. However, the way in which justices are chosen and the way in which they rule on cases are both wrapped up in politics. Even Supreme Court justices seem to acknowledge that its authority is based in part on the appearance of being removed from the back and forth of everyday politics. However, courts are important political institutions. Courts are insulated from politics in some ways because the justices serve for life and do not have to face re-election. Justices, like all people, do have personal views on political issues, and those views can seep into their decisions. Some argue that simply being near the seat of government makes justices more likely to make decisions that conform to the norms of the political system. The Supreme Court, rather than the President or Congress, has made many of this nation's most important domestic policy decisions. The court took the lead in eliminating segregation from public life, ensuring the separation of church and state, defining the rights of criminal defendants and the powers of law enforcement officials, ensuring voter equality and representation, defining the limits of free speech and a free press, and declaring abortion a fundamental right of women. However, the Supreme Court also has made some unpopular decisions, such as the internment of Japanese Americans in World War II and the forced sterilization of the poor. Justices also must depend on the elected branches to carry out their decisions, which could influence their decision-making. They need to make sure their decisions are clear and don't give much room for discretion by the people who are actually implementing those decisions. The Supreme Court and the federal court system compose the most elitist institution in the U.S. government. As we'll talk about later in the chapter, there are 9 Supreme Court justices, none of whom is elected and all of whom serve for life. They possess the ultimate authority over all the other institutions of government. Justices have the power to declare void the acts of popularly elected presidents, congresses, governors, state legislators, school boards, and city councils. The only way to appeal a determination of the supreme law of the land is to undertake the difficult task of amending the Constitution. Our judiciary system is established in the Constitution in Article 3, which is quite short. Judicial power is vested in the federal courts, headed by the Supreme Court, but it leaves most of the federal judicial system to be set up by Congress. Federal courts must be independent of other branches. They must serve for life, and their salaries cannot be reduced while in office. The Senate must confirm all presidential nominees to the federal court, and the Congress funds them. These are just other examples of the checks and balances across the 3 branches. The legal system settles disputes. There are 2 broad categories of law where they are settling these disputes, criminal and civil. Criminal cases are those in which the government prosecutes a person for a crime against society. As you can see from the slide, this is the branch of law that regulates the conduct of individuals, defines crimes, and specifies punishments for criminal acts. The government is always the plaintiff. Criminal law involves matters ranging from traffic offenses to murder. Defendants who are found guilty may be fined or sent to jail. Civil cases are those in which at least one person sues another person for violating the civil code of conduct. It's the branch of law that deals with disputes that do not involve criminal penalties. It involves disputes among individuals, groups, corporations, and other private entities, or between such litigants and the government. The losers in civil cases cannot be fined or sent to jail, but they may be required to pay monetary damages for their actions. In deciding cases, courts apply statutes and legal precedents. State and federal statutes, for example, often govern the conditions under which contracts are and are not legally binding. Attorneys for a physician being sued for malpractice, meanwhile, may search for prior instances in which courts ruled that an action similar to those of their client did not constitute negligence. Such precedents are applied under the doctrine of stare decisis, a Latin phrase meaning let the decision stand. It is the doctrine that a previous decision by a court applies as a precedent in a similar case until that decision is overruled. The courts have been established by the federal government and the state governments. Both systems have several levels. More than 97% of all court cases in the United States are heard in the state courts. The overwhelming majority of criminal cases, for example, involve violations of state laws prohibiting such actions as murder, robbery, fraud, theft, and assault. If such a case is brought to trial, it will be heard in a state trial court. The trial court is the first court to hear a criminal or civil case and can be done in front of a judge and sometimes with a jury, who will determine whether the defendant violated the state laws. This is a graphic that shows how the state and federal court systems parallel each other until they reach the U.S. Supreme Court. The U.S. Supreme Court hears appeals from both systems. If a defendant is convicted, she or he may appeal the conviction to a higher court, such as a state court of appeals, and from there to the state Supreme Court, like we saw in the graphic. The party filing the appeal, known as an appellant, usually must show that the trial court made a legal error in deciding the case. Appeals courts do not hear witnesses or examine additional evidence, and will only consider new facts under unusual circumstances. At times, an appellate court will remand a case back to a trial court for that court to grapple with the law once the appellate court has determined the proper interpretation of the law for the case. It should be noted that most criminal and civil cases are settled before trial through negotiated agreements between the parties. In criminal cases, these agreements are called plea bargains. This is a negotiated agreement in a criminal case between prosecutors and the defendant. The defendant agrees to plead guilty in return for the state's agreement to reduce the severity of the criminal charge. If a case belongs in federal court, then the next question is which federal court has jurisdiction. Cases are heard in the federal courts if they involve federal laws, treaties with other nations, or the U.S. Constitution. These are the areas where the federal courts have official jurisdiction. In addition, any case in which the U.S. government is a party is heard in federal court. Federal courts also serve another purpose in addition to trying cases within their jurisdiction, that of hearing appeals from the state-level courts. In both civil and criminal cases, a decision of the highest state court can be appealed to the U.S. Supreme Court by raising a federal issue. Remember, federal courts engage here and preside over only a limited subset of cases. Appeals to federal courts arising from state cases involve arguments that a state is not applying its laws in conformity with the U.S. Constitution. A decision from state court can be appealed to the U.S. Supreme Court by raising a federal issue. A defendant who appeals a lower court decision in federal court might state, for example, that she was denied the right to counsel or was otherwise deprived of the due process of law. The due process of law is the right of every citizen against arbitrary action by national or state governments. Due process is guaranteed by both the federal Constitution and by state constitutions. The U.S. Supreme Court is not obligated to accept appeals based upon due process and will do so only if it feels that the matter has considerable national significance. Also, in criminal cases, defendants who have been convicted in a state court may request a writ of habeas corpus from a federal district court. Habeas corpus is a court order that the individual in custody can be brought into court and shown the cause for her detention. The court then evaluates the sufficiency of the cause and may order the release of the prisoner deemed to be held in violation of her legal rights. Habeas corpus is guaranteed by the Constitution and can be suspended only in cases of rebellion or invasion. Generally speaking, state defendants seeking a federal writ of habeas corpus must show that they have exhausted all available state remedies and must raise issues not previously raised in their state appeals. Federal courts of appeal and ultimately the U.S. Supreme Court have appellate jurisdiction for federal district court habeas decisions. It's important to remember that although the federal courts hear only a small fraction of the civil and criminal cases decided each year in the United States, their decisions are extremely important. Most of the cases of original federal jurisdiction are handled by the federal district courts. Original jurisdiction is the authority to initially consider a case. It is distinguished from appellate jurisdiction, which is the authority to hear appeals from a lower court's decision. Courts of original jurisdiction are the courts that are responsible for discovering the facts in a controversy and creating the record on which a judgment is based. It's important to remember that the Constitution gives the Supreme Court appellate jurisdiction in all federal cases. Almost all cases heard by the Supreme Court are under its appellate jurisdiction. There are 94 federal district courts with 678 federal district judges. District judges are assigned to district courts according to the workload. Only one judge is assigned to each case, except where statutes provide for 3-judge court panels for special issues. The routines and procedures at federal district courts are essentially the same as those of the state courts, except that federal procedural requirements tend to be stricter. Roughly 20% of all lower court cases are reviewed by the federal appeals courts. There are 11 regional circuit courts and the D.C. Circuit, plus the U.S. Court of Appeals for the Federal Circuit. This includes 179 Court of Appeals judges. Unless reviewed by the U.S. Supreme Court, all decisions from an appeals court are final. Because of this finality, certain safeguards have been built into the system. The most important provision is that more than one judge is assigned to every appeals case. Although normally 3 judges hear appeal cases, in some instances a large number of judges sit together. Another safeguard is provided by the assignment of a Supreme Court justice as a circuit justice for each of the circuits. The circuit justice's primary duty has been to review appeals arising in the circuit in order to expedite Supreme Court action. The most frequent and best-known action of a circuit justice is that of reviewing requests for stays of execution when the full court is unable to do so. This is primarily happening in the summertime when the Supreme Court is in recess. Federal district courts are organized into 12 regional circuits, the 11 shown here plus the District of Columbia, which has its own circuit. Each circuit court hears appeals from lower federal courts within the circuit. A 13th Federal Circuit Court, the U.S. Court of Appeals for the Federal Circuit, hears appeals from a number of specialized courts, such as the U.S. Court of Federal Claims. You can see that some of the circuits are large in geographic area, while others are much smaller. For example, Pennsylvania and New Jersey alone make up the 3rd Circuit. All federal judges are appointed by the President and confirmed by the Senate. And historically, the Senate Judiciary Committee holds hearings and recommends confirmation to the full Senate with a minimum of dissent. Since the Supreme Court was established in 1798, presidents have submitted 164 nominations to the court, including those for Chief Justice. The prevailing ethos is that the popularly elected president deserves the opportunity to appoint judges. The diversity of the Supreme Court is changing. Justices are quick to argue that social background does not necessarily determine judicial philosophy, but it does have an influence on their perspectives. While some of the current justices are worth over $1 million, most started from modest or disadvantaged backgrounds. For example, Justice Thomas grew up in a house with a dirt floor, and Justice Sotomayor grew up in a public housing project. Of the federal government's 3 branches, the court bears the closest resemblance to its original form, a 225-year-old legacy. And this picture here is of our Chief Justice, John Roberts. More than 2/3 of the justices have attended an Ivy League school, and all but Justice Amy Coney Barrett on the current court attended an Ivy League school. She went to Notre Dame, not to an Ivy League law school. The Supreme Court is America's highest court and is also the only federal court established by the Constitution. The lower federal courts were created by Congress and can be restructured or presumably even abolished by the legislative branch. Like we saw in the last slide, the Supreme Court has 9 justices, a Chief Justice and 8 Associate Justices. The Chief Justice presides over the court's public sessions, and in conferences, he is the first to speak and vote. Voting then proceeds from the most to the least senior. In the court's actual deliberations and decisions, however, the Chief Justice has no more authority than the other justices. Each justice casts just 1 vote. The Constitution does not specify the number of justices who should sit on the Supreme Court, and Congress has the authority to change the court size. The court has remained with 9 justices since 1869. The system is steeped in seniority. When the 9 justices meet in conference, the most junior justice must answer the door when papers or food are delivered. As you might imagine, Justice Breyer drew the short end of the stick on this one because he served as a junior justice from 1994 until 2006. As we have discussed in previous chapters, federal judges are nominated by the President and confirmed by the Senate. They are generally selected from among the most prominent or politically active members of the legal profession. Many federal judges previously served as state court judges or state or local prosecutors. There are no formal qualifications for service as a federal judge. In general, most presidents try to appoint judges who possess legal experience and good character and whose partisan and ideological views are similar to their own views. Once the president has formally nominated an individual, that person must be considered by the Senate Judiciary Committee and confirmed by a majority vote in the full Senate. In recent years, the appointment process has been affected by increasing partisan conflict. If political factors play an important role in the selection of district and appellate court judges, they are decisive when it comes to the Supreme Court appointments. Because the court has so much influence over law and politics, virtually all presidents have made an effort to select justices who share their political views. And because of this, Supreme Court nominations have come to involve intense partisan struggle in recent decades. And you can look back at the 3 appointments made during President Trump's term to just get a little bit of a flavor for that. This is the current U.S. Supreme Court. The term of the court begins by law on the first Monday in October and lasts until the first Monday in October of the next year. Approximately 10,000 petitions are filed with the court in the course of a term. In addition, some 1,200 applications of various kinds are filed each year that can be acted upon by a single justice. 2 fun facts about the Supreme Court are that the first African American was Thurgood Marshall, and he was appointed by President Lyndon Johnson, and the first woman appointed was Sandra Day O'Connor, and she was appointed by Ronald Reagan. As you can see now, we currently have 3 women serving on the court and 6 men. Another important thing to note is that Article 3 of the Constitution and the Supreme Court decisions define judicial power as extending only to cases and controversies. This means the case before a court must be an actual controversy, not a hypothetical one, and have 2 truly adversarial parties. The courts have interpreted this language to mean that they do not have the power to render advisory opinions to legislatures or agencies about the constitutionality of a proposed law or regulation. Furthermore, even after a law is enacted, the courts will generally refuse to consider its constitutionality until it is actually applied. Parties to a case must also have standing. That is, they must show that they have a substantial stake in the outcome of a case. The traditional requirement for standing has been to show injury to oneself. That injury can be personal, economic, or even aesthetic, such as a neighbor's building a high fence that blocks one's view of the ocean. The Supreme Court also uses a third criterion in determining whether it will hear a case, that of mootness. In theory, this requirement disqualifies cases that are brought too late, such as after the relevant facts have changed or the problem has been resolved by other means. Mootness, however, is subject to discretion of the courts, which has begun to relax rules of mootness, particularly in cases where a situation that has been resolved is likely to come up again. Most cases reach the Supreme Court through a writ of certiorari, which is granted whenever 4 of the 9 justices agree to review a decision of a lower court. The term certiorari is sometimes shortened to cert, and cases deemed to merit certiorari are referred to as cert-worthy. The rule of 4 is also important, and it means that for the Supreme Court to take a case, 4 of the 9 justices must want to hear it. This is one of the only places in American democracy where we have an institution that favors the minority. The Supreme Court is the only court that also gets to choose whether or not it will hear a case. So a writ is an order by the Supreme Court directing an inferior court to deliver the records of a case to be reviewed, which effectively means the justices of the court have decided to hear the case. They often pick cases where lower court decisions are at odds, and the lower court ruling stands if the Supreme Court doesn't take the case. The Supreme Court's decision to accept a case is the start of a lengthy and complex process. Once the Supreme Court agrees to hear the case, the 2 sides submit briefs. Other groups can also submit briefs known as Friends of the Court briefs. An amicus brief means a friend of the court. Anyone can submit a brief as a friend of the court, and this includes interest groups, government departments, legislators, and citizens. These briefs provide their opinions on how the case should be decided. Oral arguments allow each side just 30 minutes to present its case to the justices. If the U.S. government is a party in the case, the Solicitor General represents the United States. The justices may reveal their predispositions during oral arguments, which can influence how the case is eventually decided. For an attorney, the opportunity to argue a case before the Supreme Court is a singular honor and a mark of professional distinction. After oral arguments, and this can happen months later, the justices meet in conference to discuss the briefs and the arguments. This is where they will decide how they want to decide the case and who will write the opinion. A decision is reached on the basis of a majority vote. If the court is divided, a number of votes may be taken before a final decision is reached. and the justices during the conference may try to influence or change one another's opinions. If the Chief Justice is in the majority, she or he gets to assign the opinion writing to herself or himself, or to an associate justice in the majority. If the Chief Justice is not in the majority, the senior justice in the majority gets to assign the opinion. Once a majority opinion has been drafted, it is circulated to the other justices. Any justice in the majority can write a concurring opinion, which agrees with the decision of the majority, but offers alternate legal reasoning. Justices who disagree with the majority may choose to publicize their disagreement in a dissenting opinion. There are many possible reasons for issuing a dissenting opinion. These include to express irritation with the outcome, to signal to the defeated side that their position did have some support, or to persuade a swing justice to join their side on the next round of cases dealing with a similar topic. Any justice in the minority can write a dissenting opinion in opposition to the majority. The Supreme Court explains its decisions in terms of law and precedent, but although law and precedent do have an effect on the court's deliberations and eventual decisions throughout its history, the court has shaped and reshaped the law. The Supreme Court justices are acutely aware of the court's place in history, and they care about protecting the court's power and reputation. This desire to protect the institutional integrity of the court can sometimes influence judicial thinking, taking the shape of judicial restraint and judicial activism. Advocates of judicial restraint are sometimes called strict constructionists because they refuse to go beyond the clear words of the Constitution in interpreting the document's meaning. The alternative to restraint is judicial activism. Activist judges, such as the former Chief Justice Earl Warren, believe that the court should go beyond the words of the Constitution or a statute to consider the broader societal implications of its decisions. Activist judges sometimes strike out in new directions, promulgating new interpretations, inventing new legal and constitutional concepts when they believe these to be socially desirable. In the original conception of the framers, the judiciary was to be the institution that would protect individual liberty from the government. The framers hoped that the courts would protect liberty from the potential excesses of democracy, and for most of American history, this was precisely the role played by the federal courts. The court's most important decisions were those that protected their freedoms: to speak, to worship, to publish, to vote, and to attend school, of groups and individuals whose political views, religious views, or racial and ethnic backgrounds made them unpopular. Today, Americans of all political persuasions seem to view the courts as useful instruments through which to pursue their political and policy goals. It's important to realize that the decisions made by the Supreme Court today will have important consequences for many, many years. The Supreme Court is not an abstract entity in far-off Washington, D.C. It reaches directly into your life with its decisions. And although the American public expects federal judges to stay away from politics, as we have seen, the appointment process is fraught with politics. Confirmation hearings are politicized, and the media feeds on any controversy surrounding an appointment. Because judicial appointments are a way for a president to leave a lasting legacy, and since federal judges are appointed for life, they can have quite an impact. Many judges are often uncomfortable stepping into the political arena. Even if judges know that their actions do affect public policy, they do not like to consider themselves a part of the political process. Most judges insist they do not make public policy. Judges who are accused of judicial activism are accused of overstepping the bounds of separation of powers, which say that legislators make laws, the executive branch enforces the laws, and the judiciary interprets the laws. So that's what it comes down to. There are three branches of government with very specific tasks according to the U.S. Constitution. It really isn't a suggestion. It is the supreme law of the land, and it's what the U.S. Supreme Court uses to decide if laws are constitutional, and who wins and who loses. The Supreme Court decisions are extremely important because there is nowhere else to go. They are the court of last resort. So that's it for Chapter 12. If you have any questions, you know how to reach me.